Hello, good afternoon. My name is Eitayo Mwemi. I'm the principal partner Law Accent, and this afternoon, our intention is to discuss the subject intellectual property for techpreneurs and IT professionals. I believe that it's going to be a very interesting one for you. So where do we start? I was caught up the other time, using this to play. As you all know, well, uh, everybody is at home and there's been a whole lot of family bonding and all of that. And this just happened to be one of those things that my last born is, playing with at home. And interestingly, it's just one of those things that we intend to discuss today. So the intention is to talk about those ideas that you bring out of your mind and then you represent in a way which then becomes what we call property from the intellect, otherwise known as intellectual property. See, generally speaking, the world is full of a whole lot of properties. We have real estate property, we have plenty properties out there, they are visible and everything. And then there is that kind of property that, even though not visible in the sense of visibility, is first created as an idea and then it is brought into being tangible. This is what we are trying to talk about today. Ideas from inception and then created in a visible format. Now, these ideas are capable of being protected because they've gone through the intellect, first a product of thought, and then they've been created, they've been expressed. In other words, for your idea to be capable of being protected, you must express it one way or the other. So what I'm saying in essence is the lockdown period affords every one of us the opportunity to come to carve out that imagination that we have in our mind and then bet it into a visible form. So is it a book you're writing, you're carving it out and you are expressing it? Is it a patent, something creative you're trying to develop? You're working at it? Or is it a music or some cinematography or some industrial design, some designs and all of that? The interesting thing about this lockdown is it gives us the opportunity to carve all of these things. And interestingly too, after this period of lockdown, there is going to be a shake in the business world, in the sense that many ideas that are created during this lockdown, they will be expressed, and we are going into a world where ideas will be given priority because the knowledge will be out there, and part of the knowledge is what we are sharing today, how you can approach that world post-COVID era, how you can approach it in a competitive manner whereby you are ready for what would come. Intellectual property is a very broad aspect of the law. So what I'm going to be doing today will be to guide you on one of those aspects. Generally speaking, when you talk about intellectual property, you're talking about copyright, you're talking about trademark, you're talking about patents, you're talking about industrial design, you're talking about any of these groups, any of these classes of works. So I am on a glasses, for instance. This could be a form of design. Interestingly, it is capable of being registered. And let's assume that this is a work of invention. Let's assume that there is something about these handles which has never been done before. That tool is capable of being protected. In other words, what I'm trying to say is that there are a whole lot of levels of protection. In one product that you could have more than one protection to it. So we take an example of Coca-Cola, for instance, which many of us are used to. You will find that there is the logo. The logo is capable of being registered as a trademark. You find the composition. The composition itself, if there is something unique about it, may be capable of being registered. And you find even on the packaging itself, the design of the bottle or the design of the cork and a whole lot of things. So these are things that you can register on their level. What I'm emphasizing is that there are a whole lot of intellectual protection you can do for your work. And don't ever imagine that there is just one. And what more than to tell you, if you are yet to take ownership of that property, if you're yet to register it, then you have not taken ownership of it. And this is the mistake many people make, depending on the kind of property we are talking about. If it's industrial design, for instance, it could interest you to know that if you do not register your industrial design first, you may be at risk of losing ownership of it. And I'm speaking from experience of a case we have been privileged to handle. One of the rules is that you must register your industrial design before you make it public. So you can imagine how many people are making their designs public. So we give an example of this. For instance, this is a design on its own. A whole lot of this thing could be capable of being registered. If the inventor of this does not register it and then has started selling to the public, automatically the inventor loses the right to even register it again. And this is the knowledge gap we are having out there, which is the key reason you cannot afford to miss a session like this. So for today, because I cannot cover everything at large, but the intention is for us to pick them one after the other and help our viewers to understand how these things work. So today, I'm going to be focusing on copyright as a form of protection for your work. Now, generally speaking, what is copyright? I love to break things down for non-lawyers. And one of the things I will tell non-lawyers usually in my sessions is, look, for you to understand all of these legal things, you must first look at what is being said from the English perspective. Law or legal terminologies is first legal terms before it becomes legal terminology. So take away all those grammars and then try to break it down in the simple English way. So we give an example of copyright. Now, copyright is from the word copy and write. And that simply means that you are given a right to something that has been expressed in writing, has been expressed vocally, has been expressed in some other ways. So what copyright is about is that you have some form of right on works that have been expressed, and we will soon get to that. I'm going to list out the different forms of works that you actually can protect under copyright. Now, I need to mention that the very core of copyright is to ensure that people, the public, do not have unnecessary access to your work to then commercialize it without your consent. That is the very key thing about copyright. And then what are the works that are capable of being copyrighted? Let me try to list them out for you. Now, there is something that is called literary works. Literary works could mean, don't forget, the key rule is you must express that thing you seek to protect. So literary work, for instance, could mean a textbook that you came up with, a storybook, some, interestingly, even a preacher's sermon is also something expressed in print, or whether it is in e-copy. What matters is that it has been expressed. It could even be computer program. I mean, a whole lot of things. Once you express, it could be in choreographic form or something. It could even be lecture notes. What matters is the originality, which we are going to come to. Now, you can also protect musical works, you can protect artistic works, you can protect even cinematograph films and all of that, and you can protect sound recordings, even broadcasts can as well be protected. These are samples of protections that you can do. And uh, what I've tried to do is to give you an at large explanation of what you can protect. You would agree with me that under all of these things, for instance, we talk about sound recording. It could be the sound itself, it could be inclusive of the movement and all of that. So you can begin to deduce additional areas of protection that comes. And don't forget, protection comes in different levels. So don't ever imagine that your work is capable of being protected just on one level. It is one of the key principles of intellectual property. Now let's move on. So for your work to be protected, it must be original and it must have been expressed. Now, what we mean by originality is that you have done some substantial, you've poured in your energy to make it something new. You've poured in your energy to make it something that is a result of your own physical, I mean, your own intellectual exertion. So it's not a copy and paste. It has to be your work. Now, without having to jump too much into all of that, that is the definition of originality in the sense of what the law envisages. Now, for your work to be capable of being protected, there are keynotes, there are points that you have to take note of. The first is you want to register your copyright. You have to either be a citizen of Nigeria or you are domiciled in Nigeria. Otherwise, your work must be such that it was first published in Nigeria. And this also applies to if you want to register your work, your brain work, as in the name of your company. And I'm going to come to something very interesting very soon, which is one key reason I need you to stay glued to this session, because there are business advantages you can bring in into structuring your intellectual work in such a way that when you bring those strategies in, it has a way of even projecting. You can reap your reward from it for a longer period than it could have been in an ideal setting. So I'm coming to that point. Is the shocker of this session I'm having with you, and I need you to stay glued and stay tuned to what I'm discussing with you this afternoon. So I've mentioned that you have to be a citizen, your work is registered, or you're domiciled in the country. Other instances where you can register your copyright is in a situation where it was first published in a country that has some bilateral agreement or some treaties, intellectual property treaty with Nigeria. Or better still, your work could be such that is your work was maybe has some affiliation with some international organizations like United Nations, World Health Organization, African Union, ECOWAS, and all of that. These are things you have to consider in in registering. Now, one of the shockers I want to give you is this. Under the Nigerian law, there is a period of ownership for your intellectual work. There is a duration that you can claim exclusive rights for your copyright. In the case, if you're registering your work in your name, the law mandates that it expires. That exclusive ownership, which you can license out and which you can use to regulate how the work is used or accessed outside, that ownership will last you for 70 years after your demise. Now, interestingly, if you are registering your work in the name of your company or something, it would last your company 70 years after publication. So you now look at it strategically. If something will last you all your life and 70 years after, compared to what will last your company just 70 years, I just wanted to look at it. Which one do you think would be of advantage? Well, so you could answer in the box below in the comment section. Let's know your thoughts about this, and then hopefully I'll get to answer that question before the end of this session. So let's just move on. Let's come to a situation where you have workers under you, or possibly you have engaged some third parties to work on betting your ideas. So I'll give you an example. Let's assume, for instance, that I'm a scientist and I'm writing a book on COVID-19, for instance, and the COVID-19 pandemic, and possibly I've gotten the solution. But then I engaged some people who were a part of the whole arrangement, and they are my employees at large, but let's assume that one of them was the one that wrote all of those things. The question is, who in that sense owns intellectual property rights in the book that was written? What the law says is that in the case of employee-employer relationship, your employee owns intellectual property rights in products that come out of the exertion of his or her brain. But the way you need to do it as an employer is to ensure that in your letter of engagement or in your employees handbook or policy guide, which you have referenced in your letter of engagement one way or the other, or which you've gotten your employees to be signatory to, you must clearly state it that any form of intellectual property that comes out of the relationship or of any work that is being done by the employee for the company shall be owned by the company. This is a very good practice. And if you're an employer and you're watching me and you've not done this in your books, you risk the chances of forfeiting your rights in things that your employees come up with as your employees or as your colleagues in business. So this is a very good practice, and it's something you should take note of. The only exception, probably the only exception is the fact that if you work in a printing press, or let's say in a broadcasting firm, CNN, channels, TV, and all of that. Now, because of the fact that that's the principal work that these people may be paid to do, the law presumes that ownership would be in the employer in such relationship. But you need to ask yourself, are you in that line? If you're not in that line, it's very crucial that you have some form of clauses that protects you as an employer of labor in owning intellectual property rights in what your team comes up with, particularly if it matters to your firm. Is very crucial point. Now let's move to the next. I'm not going to be talking too much because time is very precious and I want us to be as fast as possible. So I've tried to explain the kind of rights you have from your ownership of a copyright. You have right to control reproduction, to control public assessment, to control even translation, distribution, and a whole lot of things, even the broadcasting. Anything that has to be done on that work, you have a right to control the doing of those things. This is very crucial for you as a copyright owner. Now, I talked about the fact that I made you to stay tuned the other time so as to share a shocker with you. But I'm likely sure, I've not seen any comment yet, but I'm likely sure that you're beginning to imagine that question I asked the other time about the strategic, a strategic decision you can have to ensure that you have more ownership of your work. Now, the question I asked is, would you rather register your copyright in your private name or in the name of your business? Now, a crucial point you should look at is if I can have ownership for all my years, and then 70 years after, meaning that even my siblings, my children, everybody can still benefit from it. Or otherwise, let's assume that I'm the founder of a company. My company can only enjoy ownership for a number of years straight up. I think I'd rather go into having ownership personally, and what you should do is to then license it to your company so that way you can have ownership for all your life, and then the license can continue to run. That gives you a longer ownership and access to exclusive ownership for a longer period of time. And that is a shocker that you need to take away from this session. So, having said this, shocker, I believe that you have picked something of importance from this session, and we'll be very much around to entertain your questions and your comments, your contributions, and we would like you to also join us next week as we have another session which we would continue with regarding intellectual property right. I hope you have had fun. My name is Eyitayo Ogunlemi. Once again, I'm the managing partner, Law Accent. Thank you for watching.